Welcome back to the Making International Law in Korea, the video series. In this video, I'll be explaining to you the status of international law in the domestic legal system of Korea. Article 6, Paragraph 1 of the Korean Constitution stipulates that the treaties duly concluded and promulgated under the Constitution and the generally recognized rules of international law shall have the same effect as the domestic law of the Republic of Korea. In accordance with this, international law has been generally accepted as domestic law and incorporated into the Korean legal system. This provision stipulates that treaties have the same effect as the domestic law of Korea. There is no specific reference to customary international law, but generally recognized rules of international law is generally understood to mean customary international law. Therefore, customary international law has also been incorporated into the domestic legal system under the provision of the Korean Constitution. In this sense, Korea is monistate insofar as the incorporation of international law into the domestic law is not required for international law to apply. Both treaties and customary international law, however, need to be self-executing or directly applicable in order for it to be applied in litigation. The constitutional provision stipulates that the treaties and customary international law has the same effect as the domestic law of Korea, but it does not explicitly identify the level of the effect of international law has within the domestic legal system. Due to this constitutional vagueness, the level of effect of international law within the domestic legal system has been left to theoretical interpretation. For example, Article 5 of the Addenda of the Constitution stipulates that the treaties in force at the time this Constitution entered into force shall remain valid unless they are contrary to this Constitution. Thus, theorists suggesting that a treaty is above or on the same level of the Constitution are very rare. The majority opinion is that the both treaties and customary international law generally have the same effect as a statute as indicated by judicial decisions. Accordingly, the treaties or the customary international law that are contrary to the Constitution are invalid within the domestic legal system. In the event the treaties or customary international law are in conflict with the statute, their validity is decided based on the principle of lex posterior derogat legi a priori or lex specialis derogat legi generella. Article 60, Paragraph 1 of the Korean Constitution stipulates that consent to ratification by the National Assembly is required for treaties pertaining to mutual assistance or mutual security, treaties concerning important international organizations, or treaties of friendship, travel, navigation, or treaties pertaining to any restriction in sovereignty, peace treaties, treaties which burden with the states or people with an important financial obligation, or treaties relate to legislative matters. Based on this provision, some theories, which are supported by judicial decisions, suggest that treaties concluded with the consent to be ratification by the National Assembly have the same effect as a statute. However, treaties that are merely concluded by the executive branch only have the same effect as decrees which are law than statute. Let me move to the practice of Korea in terms of treaty making. Under Article 73 of the Korean Constitution, treaty making is within the authority of the President. All working level work for treaty making is carried out by the International Legal Affairs Bureau of the Ministry of Foreign Affairs, and procedure of the consultation with various domestic institutions should be followed before the President is able to conclude and ratify the treaties. From a procedural standpoint, there are three types of treaties that can be concluded in Korea. The treaties requiring the consent to the ratification of the treaty by the National Assembly, the treaties not requiring the consent to the ratification by the National Assembly, and the so-called treaties by notification made with a simple procedure through the Ministry of Foreign Affairs. The first step in the domestic procedure for treaty making is an examination made by the International Legal Affairs Bureau of the Ministry of Foreign Affairs. This International Legal Affairs Bureau reviews the wording of the treaty text, classifies the type of treaty, and determines whether there are legal conflicts with other treaties or other domestic laws, and whether a treaty would require the consent to the ratification by the National Assembly. With the step completed, the proposed treaty is then sent to the Ministry of Government Registration for review. It is required under the law of government organizations that the Ministry of Government Registration reviews the all proposed registration before being sent to State Council for deliberation. Treaties are treated as such. A review is made. The Ministry of Government Registration is to find out whether the proposed treaty is in conflict with existing domestic law. In addition, the Ministry of the Government Registration examines whether the proposed treaty requires the consent to ratification by the National Assembly as stipulated in Article 60, Paragraph 1 of the Constitution, and provide the opinions on it. When the review of the proposed treaty by the Ministry of Government Registration is completed, the treaty is then submitted to the State Council. Article 89, Paragraph 3 of the Constitution stipulates that the proposed treaty shall be referred to the State Council for deliberation. Before being sent to the State Council, the proposed treaty is reviewed by the Council of Vice Ministers, where practical discussions regarding the treaty text take place. When the proposed treaty is reviewed and approved by the State Council, it is then sent for approval by the Prime Minister and finally by the President. With the completion of this procedure, the person appointed by the President with full powers signs the treaty that contains the treaty text that has already been approved. However, there are exceptional cases, of course, when the treaties are signed first and then sent to State Council for deliberation. If a signed treaty requires ratification by the President, it must go through the ratification procedure again. However, practically, a treaty concluded through the resolution by the State Council, approval of the Prime Minister and the President, they are ratified without additional ratification procedure involving President. Article 60, Paragraph 1 of the Constitution stipulates that the National Assembly shall have the right to consent to the conclusion and ratification of treaties. In other words, the consent by the National Assembly is certainly required for treaties pertaining to mutual assistance or mutual security, treaties concerning important international organizations, treaties of friendship, trade, and navigation, treaties pertaining to any restriction in sovereignty, and peace treaties, treaties which will burden the state or people with an important financial obligation, or treaties related to legislative matters. The administration submits to the National Assembly a motion for the consent to the ratification as a general item, and not as legislative bill. The National Assembly decides only on whether it consents to the ratification of the treaty, which is ultimately decided Assembly at plenary session after going through an internal procedure of the National Assembly. The resolution is passed if more than half of the all votes cast by more than one half of voters eligible vote in favor. Regardless of whether treaties are formal or informal, or whether the consent to the ratification by the National Assembly is required or not, all treaties that have become binding within Korea are promulgated domestically by being noticed in the official gazette. In Korea, there are treaties that are signed and concluded with the full power of the Ministry of Foreign Affairs without needing to go through the whole procedure of the deliberations by the State Council, President's approval, or consent to the ratification by the National Assembly. These are referred to as 고시류 조약, which can be put into treaties by notification. These treaties refer to supplementary agreements concluded within the scope authorized by the treaty provision in order to the implementation or execution of the original treaty, or minor modification by an organizational resolution of a multilateral treaty provision adopted by the international organization. The treaties that fall into this category are concluded by the Minister of Foreign Affairs in consultation with related ministries. Generally, treaties that are notified in the official gazette we call in 관보 as a treaty, and promulgated, whereas the treaties by notification are posted in 관보 as 고시 in notification by the Ministry of Foreign Affairs. Pursuant to the Vienna Convention on the Law of Treaties, Article 2A, there are no doubts that treaties by notification are considered treaties that are legally binding in Korea.